experience. Now, this is questioning at what time. There are two matters. Directly. So if the first matter, they say if it is a prior teaching experience, Lordship probably would be hearing it along with the others.
12th.
In the meantime, my lord, I have been able to, because yesterday I placed one judgment, I've been able to get hold of some other judgments directly on that.
All right. 2, the petitioner seeks a passover.
Passover. I have no difficulty. I can wait.
We can continue with 3.
Yes.
All right.
My lord, item number 3, my lord, my challenge is twofold challenge. First, my lord, I am not challenging whether 10 marks are to be can be given or not. I say 10 marks may be given. I have no problem.
Who are you? Who are you?
I am a candidate, fresh candidate who have applied in the
Second SLST.
SLST for 1911. My lord, my challenge is you can give 10 marks. There is no problem with that. The competence of the legislature has decided. My point is, when can these 10 marks be given? After interview or before interview? First. Second point, my lord, this prior teaching experience can be given to anybody except those candidates who have lost their job because of the illegalities in the selection process, and the Supreme Court has declared the selection process null and void. This is my second point, and my first point is
that means anybody who participated in the 2016 recruitment process is not eligible.
Not eligible. This is my second point. First point is, when can this 10 marks?
Yes, this I followed. Yes.
My lord, only for that, my lord, if your lordship kindly comes.
Page number 27.
Page 27.
Who is opposing item 3?
Well,
Sorry, item 2 and 3, my lord.
Oh, you are praying for
well, I filed an applications because
in which matter? 2 or 3?
both the matters.
Both.
Because I am appearing for the untainted candidates who were serving and they were honest, but ultimately because of the circumstances, they lost their job and now well, they have participated.
All right.
Now, if prior teaching experience, whatever lordship decides, if it goes against me, I would be affected. For that reason, I have filed an application.
My lord, my
can 3.
We have also filed. I'm led by Mr. Mitro.
All right. Same thing. What is the number of your application? Can 2.
Can 3.
Can 3 is here, but then 1 and 2, yours must be 1. This is 1.
But can 1 has not been served upon us.
Whatever, 1 and 2, the files are not here.
Can 1 has not been served upon us. Can 2 and 3 has been served.
Take a button.
They will reply or your lordship.
Lord, kindly pass it over, my lord. And keeps it up, my lord, at 11:30 or 12, my lord.
Let them start. So
We'll have to.
Notes. You take down notes. Let him come. One batch is on 12th.
yes.
Let me
Lord,
just.
this is a separate matter regarding interpretation of
That's the
two
other
rules, my lord.
point is being raised today. Not the same point.
But it's not the same point.
Yes.
Your lordship comes to page
এক মিনিট যাও, বুলা কে লাও।
1 আর 2 কে আনান। 18 নম্বর তো এটাই কোড। Yes.
And at page 27 of my request of all petitions are coming.
No, this is a different point that has been raised. This is not there. So this is the point is different. Connected with that point, not connected with the SLST, because there may be so many matters with that point. And if it appears that it is to be heard on 12th, I'll place it on 12th. Yes. Right. Yes.
well, when is fundamentally different point, no doubt.
Absolutely.
When
the main
survives, it's fundamentally different.
provided it survives.
Yes.
Right.
My lord, page 27 of my. This is the rules, my lord. Rule 2
Shishi.
and within 11 portion mana Rule 2K, page 27. What is an interview list? Malad, may I read?
Hmm.
Interview list in respect of SLST state level selection test means in case of vacancies in the post of assistant teacher, a list of candidates prepared by the Central Commission to be called on merit for oral interview and lecture demonstration category wise on the basis of preliminary merit score, which is that is score for written examination and W got TET. TET is not applicable for us written examination and academic score in the ratio of 1:1.6. So, my lord, this is the interview list written examination score and academic score in the ratio of 1:6. Now,
No,
my
no,
lord,
it is not 1:6. It is 1.6 is to
1
So it's a different.
1 is to 1.6.
merit list in respect of SLST state level selection test means in case of post for list of candidates for vacancy wise on the basis of merit which shall mean suitable to what has been stated in Rule 2 1K marks obtained in oral interview, lecture demonstration and prior teaching experience. So, my lord, my case is prior teaching experience should be awarded at the time of preparation of the final merit panel, considering the marks of written score, interview score, and lecture demonstration, and thereafter prior teaching, not at the stage of interview for calling a candidate for interview.
What is the marks, full marks of the examination
My lord, 100. My lord,
and
for-
the breakup?
yes, my lord, for that schedule to page 36.
36.
Lord, this is schedule 2A.
Written examination 60. Educational qualification is 10. 70. Prior teaching 10. 80. Oral 10. 90. Lecture demonstration 100 marks.
So, my lord, I say this written examination marks and academic score will be considered for calling a candidate for interview. Thereafter, after the interview, at the time of preparation of the final merit list, the prior teaching experience
All
marks.
right, see, today 2 applications are not on record. First. Second, the written examination marks have not been declared. So we'll post this after.
No difficulty.
Right.
12 only thing, my lord, why I am apprehending. Today the results will be published in all probabilities.
All right.
If the results are being published, calculating these 10 marks, then my lord, entire thing will be.
They have not yet calculated written examine. Today the result, if it is published, it is only for the written examination.
No problem. Let that assurance be given.
No, they
Because-
can. How can he give assurance?
No, my lord. What I am telling on lordship, the candidates directly went to the commission. The commission says the result that will be published calculating the written examination marks, academic score, and prior teaching experience.
But that is true. That's true. He is right because that's the law requires.
The result that will be published today.
Yes.
But this is not the result. The wording is not the result. It is
Read the
under-
marks.
no. It's a interview list.
All right. So if
Interview
it
list
is
should be comprised of what things are there under 2K. Dr. May kindly have a look at that.
yes,
Kindly see. Interview list in respect of the SLST means in case of vacancies
Until.
in the post of assistant teacher, a list of candidates prepared by the Central Commission to be called, all these parts not that much important, on merit for oral interview and lecture demonstration category wise. Now this is the important. On the basis of preliminary merit score. Kindly pause for 1 minute. What is statutory preliminary merit score? That has been defined within the bracket. That is score from written test and or TET. Now here and or because for up to upper primary, they get a teacher eligibility test. So that is kind of, I would say, educational, how to teach. They get that marks. So that's come under TET. And for us, it's a written test. Kindly read this: written test and academic score. Now, what is the academic score? Kindly straightaway kindly come to, there is a
Schedule.
defined under schedule 2. Well, under schedule, may I just say and thereafter show. There are 3 things. A, B, C. A equals to 9, 10. B equals to 11, 11, 12. C equals to upper primary, which is completely different because then central government, NCT, all others comes. Now we here come under A and B. Kindly come A and B. Under A, Malad, there is a bucket of the academics. Under 2, this academics has two components. Component number 1, what is course in the educational institutions, and component number 2 is prior teaching experience. Therefore, the interview list, which has to be on the basis of 1.6:1. That means if there are 100 vacancies, they will call 160%. That's the ratio. That has to be on the basis of statutory prescription. Now, interesting part is what possibly my learned friend might like to show is that under 2K, after 2K, there is a definition is of merit list. Now, this is one rule caters to all the categories. Now, if I put 3 categories, 9, 10, 11, 12, upper primary. For upper primary, it is completely different for them. They get it last. Why? Maybe the logic is they get the TET, unlike we don't get it. So for us, that is 9, 10 and 11, 12, under the bucket of the academics, prior teaching experience comes. So, Malak, this is and no, of course, he has not finished. Just to give, Malak, in case Lordship finds that in case there is a, because my learned friend might like to show the definitions, in case your Lordship finds that there is a kind of any conflicting view in any way, kindly take a look at definition rule 2, because everywhere, my lord, this is a very fundamental that all definitions are, well, I would not use my own words, it's there in the rule itself. 2.1. In the rules, unless the context otherwise requires. So all definitions are contextual.
My lord, I am appearing for the SSC. We have to make the interpretation, not the candidates first.
No, Mr. Bandhavadha, we suffered a lot. We lost our jobs.
We know that, but I have to make my no. Suffered a lot. Have you made an
All
application or
respect,
not? Allow us. With this,
No,
not
no,
that. Don't. Let's
I am-
serially. Let's go by serially. You are
Mr.
either.
Bandyopadhyay, nobody is shutting you out. You,
No, I
you go ahead
understand,
and
but
I'm going to hear you.
I understand, but not
Making
this.
submission, let him make his submission.
It's about our conditions also. We
Yes,
were
yes, you
working-
make your submission. I'll hear the commission also. It's
Yes,
not that
yes.
the commission will not be heard.
Well, the very core principle of if there is a conflict of little bit of divergence between the definition clause and the direct controlling clause. Controlling clause is the schedule itself, schedule 2 itself. In that case, the principle of unless otherwise requires has to be taken into consideration. Now, what is the little bit of conflict? Little bit of conflict, Lordship may see it. Actually, not a conflict, it's a superficial conflict. That 2K talks about the interview list, clear cut. And for 9, 10, 11, 12, it clearly mentions that the preliminary merit score means two components, academic score and the written test. That's all. Now, what is the academic score for that, my lord? That schedule 2 under the bucket of the academics. Here the word there is here academic score. Academic is an adjective. But thereafter in the schedule 2, they have used the academics, which is in plural, which is a bucket. Under the bucket, they have put the, my lord, the prior teaching there itself. Now, my learned friend might like to show the definition, next definition of merit list that is in conflict. But that's, my lord, it's a superficial, that there is no conflict. Merit list simply defines two things. There is basically two definitions. Kindly have a look at merit list. Merit list in respect of the SLST, state level selection test, means, this is the first meaning. In case of posts, a list of candidates prepared category wise. But this is the first. And second, on the basis of merit, now which shall mean. So now this part is actually not defining merit list. This part is on the basis of merit means what? Shall mean in addition to what has been stated in rule 2 1K, marks obtained in oral interview, lecture demonstrations, prior teaching experience, and shall. So here prior teaching experience is there, but for upper primary, can you have a look schedule 2C. So for C, they get it 5 marks because they get TET marks. We don't get it.
It is not.
No, I'm trying to say that rulemaking authority recognized that situations are different. For 9-10, they have made for academics under 2 pillars, the qualifications and the prior teaching experience. And that is in sync with the rule. He is not questioning the virus of it. I'm trying to say that. He is saying that by way of an interpretation itself, that they should get it. I say the schedule doesn't say so. But that's my preliminary submissions. And there are judgments by the Honorable Supreme Court that even for shortlisting, prior weightage, that can be done. It's a very recent judgment.
Lord, can I make my submissions?
No, the petitioner has not
Yes, yes,
even
this is submitted.
proceeded. Let him place his case.
Then why Mr. Dhar was started to submit?
Mr.
He-
Baldwin, that
it
I
was-
too worried. I mean, that
It was.
What to worried?
It's all right. It's all right. I'll
Mr.
hear
Dhar,
you.
don't pass that stuff comment. Do not try to hijack everyone's case.
No, I'm.
My lord, here he is, they are making this submission, and in the Supreme Court, they are saying this act is bad. This is the
Yes,
whole
please,
problem
petitioner.
of them.
Petitioner.
My case,
Contradictory.
the Lordship has seen the rule and as well as definition rule and the schedule. Well, the intention of legislature in any legislature cannot be to cause injustice to one group and justice to another. My lord, the whole intention of providing prior teaching experience, my lord, that has also been stated by the defendant is the object is to get better teacher to teach the students. This is the only possible, my lord, reason for introducing prior teaching experience. Now, my lord, this prior teaching experience should not be awarded in a manner so as to cause injustice to other candidates who do not have that. Because, my lord, previously in the 2007 recruitment,
This batch of or this writ petition has been filed by a batch of candidates who are absolute freshers.
freshers.
Yes.
My lord, previously in 2007, there was recruitment rules in for SSC, my lord, there was a prior teaching experience, but a separate percentage of seats, 10% of total seats were reserved for these in-service candidates to avail the benefit of prior teaching experience and like that nature. So, my lord, there was no injustice. Now, it has to be construed, my lord, harmoniously, definition clause and the schedule. Firstly, my lord, the definition clause very rightly stated that when prior teaching experience is to be given so that it does not cause any prejudice to any fresh candidate. Now, my lord, take a situation. A fresh candidate out of 60 scored 55 and a in-service candidate scored, my lord, 44, 46. Now, with this teaching experience, he get a call for interview and this candidate even securing more marks, my lord, in the written examination does not. That is why taking this into consideration, my lord, the legislature thought it fit that this prior teaching experience is only for the object of getting a good quality teacher, nothing else. That marks has to be given at the time of preparation of final panel, not at the time of calling a candidate for interview, because that will cause injustice. That is why, my lord, 2L specifically.
It will cause injustice if it is at the interview stage and not at the final merit list stage. It will be injustice at any stage if it
will
is
be
given.
injustice at any given stage because it creates at the screening level, it creates a advantage to a group of class among a class.
Yesterday, this is
Class
what
among
the issue
class.
that was placed by Mr. Bhattacharya.
Yes, my lord, that is one issue. I say even if these 10 marks can be given, take a situation, your lordship affirms that no, these 10 marks can be given for the object of getting a better teacher. Now the question will come, when will these 10 marks be given so as to mitigate the injustice that will be caused to the fresh candidates? That is the, my lord, that also I must say, my lord, the rule also provides that no injustice is caused to any fresh candidate. That is why these 10 marks are to be given at the time of preparation of the final panel. And my lord, your lordship knows, if your lordship kindly comes to schedule 2,
Yes.
page 36, my lord, academics, it is only a heading, my lord, but it's specifically subhead. Academic is one heading. My lord, two, academic is one heading, practicing experience is another heading. It's not that under academics, it is practicing experience. Under the column 2, there are two heads, academics and practicing experience. It's not that under academic, it is practicing experience.
I think factually this is, just place it. I think factually.
My lord,
you're not
may I?
right.
My lord, one, if your lordship is A, written examination, Weimar mark 60, then 2 academics.
Yes.
My lord, then after academics, it's being practice, completely different. And practicing experience, my lord, has no relation, has no relation with the academics.
See, one thing
Yes.
in this schedule 2, academics
Yes.
has been described under 2 heads, A and B. But in the upper primary, see,
Yes.
academic score is 10 separate,
Clearly
TET
different.
weightage 40.
Yes, my lord.
So they have tried to create some type of distinction
Yes.
by mentioning sub clauses.
Because, my lord, in upper primary, first, there is nothing like written examination and practicing.
A prior teaching experience, 5 marks have been reserved.
For upper primary.
Yes,
But for TET, my lord, for written examination,
that is separate.
that is completely separate.
40 marks, that is separate.
Separate.
Yes.
What I am on in schedule 2, my lord, under 2 academic, there is A is educational qualification, B is practicing. That under academic, it's only educational qualification. Practicing experience is a completely different thing. And my lord, this rule
If 2
2
consists of A, then 2 will consist of B also.
is considered B, but the practicing experience does not include academics, my lord. That is why under 2 educational qualification, practicing. And my lord, it has to be read in consonance with rule 2L. My lord, if your lordship once again for my satisfaction comes
Yes,
to
yes, merit list you've placed.
my lord, this is my first point. This is my first point. My lord, my second point is your lordship has already seen the judgment passed by the Supreme Court. If your lordship kindly comes to page 131.
Petition. Petition is 130.
Petition is 130. My lord, 2 paragraphs I will read for you. Paragraph 45 and paragraph 46. The last question relates to the relief and whether it requires any modification. If
Where are you reading, please?
page 131, paragraph 45.
Yes.
That void point.
Yes, yes.
And the last question relates to relief and whether it requires any modification. We find no valid ground or reason to interfere with the direction of the High Court that the services of the tainted candidates where appointed must be terminated and they should be required to refund any salaries. This part tainted candidates for the time being is not in question because
Nobody is raising this issue.
according to me, my lord, if your lordship has rightly called for the list, why? If your lordship goes through in details, Supreme Court has defined who are the tainted candidates. Weimar mismatch. There is out of
Whatever,
time.
we are not going into that.
For the present.
Yes, present we are not going.
My lord, paragraph 46. For candidates not specifically found to be tainted, the entire selection process has been rightly declared null and void. My lord, I stop here for a moment. When a selection process has been declared null and void, everything which has flown from that selection process is void ab initio, is null and void. Nothing can be gained from that selection process which has been declared null and void.
All right.
Declared null and void due to the egregious violations of and difficulties which violated Article 14 and 16 of the Constitution. As such, the appointment of these candidates are cancelled. However, candidates who are already employed need not be. Here I am not
placing. All right.
my lord. So when a selection process, it's not only the appointments, my lord. A selection process, as there is a difference between selection process and appointments. Once a selection process has been declared null and void, my lord, there is no scope of giving any benefit from that selection process.
Yes.
My lord, and that is why, my lord, these 2016 candidates who have lost their job because of the declaration of the selection process as null and void, they are not entitled to any sort of benefit. This is my first point. Second, if your lordship kindly sees, for candidates not found to be specifically tainted, are they not found to be specifically tainted? That they have to establish before your lordship first. Why I say this before your lordship? Because, my lord, this says not specifically.
Is the list published by the commission on the
Your lordship,
website?
there is something. A list has been published.
Is it there in the website?
Yes, yes, my lord, yes.
All right. So anybody
No,
can.
my lord, there is a
No.
Show me that my name is there. How?
a list has been published by the commission. But, my lord, your lordship knows who are tainted has been defined by the Supreme Court. A Weimar mismatch, after expiry of panel, and out of panel. This list only contains candidates who have Weimar mismatch and out of panel. Candidates who have been appointed after expiry of panel, that is stated in paragraph 31. My lord, kindly come.
Where is the list available?
My lord, in
Please.
the website that does not contain the name
Hey,
of
Shailesh,
candidates appointed.
please
after
please
expiry.
find out that list. Yes.
Mr. My lord, if your lordship
You have
kindly
a
come to
copy?
paragraph 31.
Let me see once.
My lord, paragraph 31 of the my repetition one.
31. No, this at least I did not get it, so I'm not aware.
No,
Very well.
my lord,
I am not
paragraph
aware.
31.
Let me just see what is there. Paragraph 31.
Paragraph 31, my lord, of the writ. Page 125.
আমাদের একটা ওয়াইফাই তে খুললে হবে।
Paragraph 31 of the judgment.
The judgment.
Yes.
Page 1, may I read? When Wbssc has also tried to justify extension of the term of span, as noted above, the time period of 1 year specified in Rule 21 for the destruction of Weimar-sheet coincides with the time period specified for the validity of the panel. There is no doubt that counseling process and appointments made to the post of assistant teacher for classes 9, 10 and 11, 12 were made after expiry of the panel. This is an illegal and contrary to the rules. Reliance on the orders of judgments of High Court in stray cases of rank jumping, where the High Court directed to appoint candidates after expiry and validity of the panel would not have any significant impact. The court at that stage was not concerned and aware of the illegalities in the appointment procedure, and that not specifically examining the question of appointment after expiry of the panel. So, the Supreme Court has clearly stated appointment made after expiry of the panel, counseling and appointments made after expiry of the panel is illegal. So that those candidates who have been appointed after expiry of panel and appointments made thereafter is illegal. So they cannot be
The
considered.
panel that has been published,
No, that
does it
initially
contain this one, the list that has
does
been
not
published?
contain the name of any of the candidates who have been appointed after expiry of the panel. And I say this, my lord, with responsibility, with the addition that even a single candidate found after expiry of the panel, your lordship will dismiss me with exemplary cause for misleading this honorable court.
Well, I think my learned friend is going to completely. a
Lord, can I make submissions?
No, sir. I'll hear the commission later on.
আচ্ছা।
Yes.
My lord, so
This. What is this?
we are sending it for a print. We had the yesterday.
Okay.
My lord, whatever be the list, I say this with responsibility. No, even a single candidate's name is featuring in that list. I have checked it personally. After expiry of panel, no candidate's name is there. So even for admitting there who are appearing before your lordship that they are not found to be tainted, they have to show that they have been appointed within the time period of the validity of the panel and not after expiry of the panel. Well, these are my 2 points. And
before the commission,
All right.
before the commission reply to this submission, may I add whatever points I have now so that they can reply incomprehensive.
Is it the same thing?
Item 2, my lord.
Yes, yes, item 2, the,
Same argument, 2, 3 additional points.
all right. What is the number? আচ্ছা কি দেখুন। Yes, item 2. আসেনি? When did you file it? Yes, so it's not here.
My lord, I have only received can 1 and can 3 probably, and no can I have.
Well, I have served everyone, so
All applications to be
yes.
circulated. Otherwise,
না, আমাকে
nobody should be taken by surprise. What
That-
is the addition? দেখি 2 নম্বরে ফাইলটা একটু দিন না।
না,
Yes, yes.
But yesterday I have seen the entire argument on YouTube. So I'll not repeat whatever submitted yesterday also.
But yesterday's point was different.
Not really. One of the point is with me in my writ petition.
This one.
In yes, item 2.
Yesterday, the virus of the 10 marks, whether it all at all it can be given
That is
or
one
not
of the
was
point I
issue.
have taken.
All right. Barring that, what is the other point?
Yes.
Today, another point is taken as to what stage the 10 mark is to be
It is,
allotted.
one of the point in my petition.
What is the other point?
Now to support the second contention if you see kindly take some the definition clause once K and L to decide at what stage.
Yes. Where is it in your petition?
In page 80.
80. Yes.
Now K is the interview list.
Hmm.
Means in case of vacancies in the post of assistant teacher, a list of candidates prepared by the Central Commission to be called on merit for oral interview and lecture demonstration category wise on the basis then preliminary merit score, that is score from the written test and or TET for upper primary and academic score. Therefore, for preparation of interview list, they have to prepare it based on academic score, academic, not S. This is singular number, academic score. And then ratio. To find out whether teaching experience can be added prior to interview, can be ascertained from the next definition, merit list. Because this experience marks cannot be given 2 times, before interview and after interview. It has to be given either before interview or after interview. Now, merit list means